Welcome friends for UPSC Labour Enforcement Officer exam. So what we will do, जो 2015 में यूपीएससी का पेपर हुआ था उसको हम लोग सोल्व करेंगे, ठीक है। सो गाइज 2015 में जो पेपर है वो यूपीएससी एएलसी के लिए हुआ था, लेकिन क्योंकि यूपीएससी एएलसी और यूपीएससी एलईओ लेबर एनफोर्समेंट ऑफिसर का सिलेबस या पेपर एक ही होता है, इट इज नॉट सिमिलर, इट इज सेम। तो इसलिए हम 2015 का भी पेपर फॉर यूपीएससी लेबर एनफोर्समेंट ऑफिसर के लिए, आप लोगों के लिए हमने डिटेल्ड सॉल्यूशन के साथ हम लोग लेके आए हैं, ठीक है। सो गाइस, बिफोर वी स्टार्ट विद दिस पेपर, एंड ऑफ कोर्स किसी भी एग्जाम के लिए प्रीवियस ईयर के पेपर देखना और प्रीवियस ईयर के पेपर से सीखना इज वन ऑफ द फर्स्ट एंड वेरी इंपॉर्टेंट स्टेप्स, ठीक है। तो बिफोर वी स्टार्ट विद द क्वेश्चंस, एक एक करके हम लोग शुरू करते हैं। मैं आपको तीन चार चीजें विच आई वांट टू शेयर विद यू अबाउट दिस पेपर। सो गाइस, सबसे पहली बात, हमारे पुराने पेपर से हम लोग क्या सीख सकते हैं कि किस सेक्शन से कितने सवाल आते हैं, या इन अदर वर्ड्स कौन सा सेक्शन ज्यादा इंपॉर्टेंट है, कौन सा सेक्शन कम इंपॉर्टेंट है। सो गाइस, उसके लिए हम लोग क्या करते हैं, हम लोग 2015 और 2017 का पेपर हम लोग कंपेयर करते हैं, जो भी आपके सामने है। सो अगर आप लोग देखोगे, जो 2015 का जो पेपर था उसमें लेबर लॉज के अप्रोक्सीमेटली 45 सवाल आए, लेकिन 2017 में लेबर लॉज के अप्रोक्सीमेटली 60 सवाल आए। ऑन द अदर हैंड, अगर इंडियन पॉलिटी के देखो आप, 2015 में 24 आए और इंडियन पॉलिटी के अगले पेपर में सिर्फ 10 सवाल आए। इस तरह करंट अफेयर के इसमें 6 आए, इसमें 10 आए। सो गाइज, इससे हमें क्या समझ में आती है बात, आई विल कम टू दैट। बिफोर दैट एक और पेपर देख लेते हैं यूपीएससी का, विच इज अगेन यूपीएससी का रिक्रूटमेंट एग्जाम है, जो ईपीएफओ का हुआ था, पहले 17 में हुआ फिर 21 में हुआ, ठीक है। सो लेबर लॉज आईआर के 2017 में 20 सवाल आए, जो कि 2021 में 10 सवाल आए, ठीक है। कंप्यूटर नॉलेज के इसमें 5 आए, इसमें 10 आए अगली बार जो पेपर हुआ। सो गाइज, पहली चीज जो हमें इससे सीखनी है वो ये है कि अबाउट वेटेज ऑफ डिफरेंट टॉपिक्स, हमें इससे कुछ नहीं सीखना है, ठीक है। और क्योंकि हम लोग काफी सारे रिक्रूटमेंट एग्जाम करते हैं यूपीएससी के, फिर एग्जाम दोबारा भी होता है इवन विद इन सेम एग्जाम, वन थिंग विच वी कैन कॉन्फिडेंटली से कि यूपीएससी के रिक्रूटमेंट एग्जाम में वेटेज वेरी करता रहता है। फॉर एग्जाम्पल, अभी जो 15 में पेपर हुआ आप लोगों के लिए, ठीक है, उसमें एचआरओबी के 10 सवाल आए और 17 में एचआरओबी के 8 सवाल आए। हो सकता है जो पेपर अब 2023 में होगा, 2022 वाले लोगों के लिए, हो सकता है उसमें एचआरओबी के 20 से 25 सवाल भी आ सकते हैं। So guys, first thing which you have to learn is that let's not go with any preconceived notion कि ये टॉपिक ज्यादा इंपॉर्टेंट है, ये कम है, इससे ज्यादा सवाल आते हैं, इससे 5 आते हैं, इससे 10 आते हैं। यूपीएससी के रिक्रूटमेंट एग्जाम में ये चीज हमेशा वेरी करता रहता है। तो ये है पहली बात। दूसरी बात, लेट्स कम टू कट ऑफ। सो जो एलईओ का पेपर हुआ, लेबर एनफोर्समेंट ऑफिसर का 2017 में, उसमें जनरल कैटेगरी का रिटर्न का कट ऑफ था 160 आउट ऑफ 300। इसका मतलब हर एक सवाल कितने का था, 2.5 मार्क्स का था। इसका मतलब जिसने अप्रोक्सीमेटली 120 में से 65 सवाल किए, उसको इंटरव्यू के लिए कॉल आ गया। अब गाइज अगेन, ये कब हुआ, 2017 वाले पेपर में जो एलईओ का हुआ, ठीक है। अगेन गाइज, जो कट ऑफ का नंबर भी है उसमें भी सिग्निफिकेंट वेरिएशन होता रहता है। एंड आई गिव यू अनदर एग्जांपल टू शो द सेम थिंग। ईपीएफओ का जो पेपर 2017 में हुआ, उसमें जिसने 120 में से 58 सवाल ठीक किए थे, नेगेटिव मार्किंग के नंबर काटने के बाद, उसको इंटरव्यू कॉल आया था। ऑन द अदर हैंड, जब यही पेपर 2021 में हुआ, तो 120 में से जिसके 78 या 80 के आसपास, अभी कट ऑफ आना बाकी ऑफिशियली, 78 से 80 के आसपास जिसके सवाल ठीक हुए 120 में से, उसको इंटरव्यू कॉल आया। सो गाइज, कट ऑफ डिफिकल्टी लेवल के साथ ऊपर नीचे होता रहेगा। अगेन, कट ऑफ के साथ भी, कट ऑफ के नंबर के साथ भी एग्जाम में नहीं जाना है। जस्ट डू योर बेस्ट। हो सकता है आपके एग्जाम में कट ऑफ 120 में से 80 सवाल चला जाए, हो सकता है पेपर डिफिकल्ट है तो आपके एग्जाम में 120 में सिर्फ 55 सवाल पे ही तुम्हारा कट ऑफ रुक जाए। सो दूसरी बात क्या, कट ऑफ के पॉइंट ऑफ व्यू से भी एग्जाम में प्री कंसीड नोशन नहीं रखना है। जस्ट डू योर बेस्ट। ठीक है। नेक्स्ट थिंग गाइज, यूपीएससी एलईओ के एग्जाम में जो टाइम मैनेजमेंट है एग्जाम वाले दिन की, मेरा पेपर होगा नहीं होगा ये सब होगा, उसका वैल्यू इतना ज्यादा नहीं है। क्यों? क्योंकि 120 सवाल हैं, 120 में से 15 या 20 सवाल आएंगे न्यूमेरिकल एप्टीट्यूड के। उसके अलावा जो बाकी 105 या 100 सवाल होंगे वो सारे थ्योरेटिकल हैं। लेबर लॉज, एचआर, ओबी, पॉलिटी, तुम्हें 10 सेकंड में देख के पता चल जाता है कि तुम्हें आता है या नहीं आता है। सो अगर इस वाले एग्जाम में हम लोग फेल होते हैं तो हमेशा हम फेल इसलिए होंगे कि हमें आता नहीं था। इस कारण हम कभी रेयरली फेल होंगे कि टाइम मैनेजमेंट में हम कुछ मार खा गए। ऑफ कोर्स बेसिक हाइजीन इन प्लेस रखना पड़ेगा। अगर तुम लोग किसी एक ही सवाल पे 8 मिनट लगा दो फिर तो ऑफ कोर्स यू आर इन ट्रबल। पर अगर बेसिक हाइजीन मेंटेन करके चलते हो टाइम मैनेजमेंट का, तो इस वाले एग्जाम में टाइम मैनेजमेंट के लिए घबराने का जरूरत नहीं है। फोर्थ एंड लास्ट थिंग जो मुझे शेयर करनी है आप लोगों के साथ, वो ये है कि आपके पास लेबर एनफोर्समेंट ऑफिसर का जो एग्जाम है, ठीक है, उसके लिए आपके पास एक ही पेपर है 2017 वाला, लेकिन सिलेबस सेम था। सो 2015 का भी रेलेवेंट है एएलसी का। फिर एएलसी का 2013 का पेपर हुआ था वो भी है, हम लोग तुम लोगों हमने अवेलेबल करवा भी दिया है, पर उससे कुछ ज्यादा सीखने को नहीं है क्योंकि उस टाइम नंबर ऑफ क्वेश्चन भी अलग थे, डिफिकल्टी लेवल 120 की जगह 100 सवाल थे। तो वो पेपर कर लेना, पर उससे कुछ ज्यादा सीखने को नहीं है जो 2013 में हमारे पास आया था। बट जो यूपीएससी के बाकी रिक्रूटमेंट एग्जाम होते हैं जैसे कि एएलसी या एलईओ तो अपना हो ही गया, ठीक है, इसके अलावा जो बाकी रिक्रूटमेंट एग्जाम है जैसे ईपीएफओ, ईएसआईसीडीडी, एडमिन ऑफिसर, अगर वो डीआरडीओ के लिए हुआ, जीएसआई के लिए हुआ, किसी के लिए भी हुआ है, स्टोर ऑफिसर, कैंटीन मैनेजर इन सीएसडी, ये सारे रिक्रूटमेंट एग्जाम में जो सवाल हैं उनका डिफिकल्टी लेवल भी इज टोटली सेम, नॉट इवन सिमिलर, इज सेम एज योर एग्जाम जो आप है। तो इन सारे एग्जाम के भी वो वाले सवाल, जैसे इन वाले एग्जाम में किसी में इंग्लिश भी होगा तो इंग्लिश छोड़ देना, लेकिन अगर इस एग्जाम में करंट अफेयर है, पॉलिटी है, लेबर लॉज है, एचआर है, तो वो वाले सवाल भी तुम्हारे लिए उतने ही रेलेवेंट है, न्यूमेरिकल एप्टीट्यूड है। इनफैक्ट न्यूमेरिकल एप्टीट्यूड के लिए सिर्फ ये ही नहीं, जो यूपीएससी के रेगुलर एग्जाम है, इन सारे एग्जाम्स को हम क्या बोलते हैं जो मैंने लिखा है, ये है रिक्रूटमेंट एग्जाम। जो यूपीएससी के नॉर्मल एग्जाम है, कौन कौन से, सीआईएसएफ, सीएपीएफ, और जो यूपीएससी सीएपीएफ या यूपीएससी सिविल सर्विसेज का जो सी सेट का पेपर होता है, उसमें जो न्यूमेरिकल एबिलिटी वाले सवाल हैं उनका डिफिकल्टी लेवल भी इज टोटली सेम एज व्हाट इज योर रिक्वायरमेंट। सो यूपीएससी के 2-3 एग्जाम है जिनका डिफिकल्टी लेवल अलग है, वो है सीडीएस, एनडीए, तो ये नहीं करने हैं। इनके अलावा जो बाकी एग्जाम है सीआईएसएफ, सीएपीएफ, सीसेट, इनके भी न्यूमेरिकल एप्टीट्यूड के सवाल, इनफैक्ट सवाल रिपीट भी होते हैं। ऐसा भी मुझे अभी याद नहीं है, मैं अगर दिखा देता, ऐसा भी होता है कि एक सवाल आ गया 2015 में किसी सी सेट में या किसी, फिर 2021 में तुम्हारे पेपर में आ गया वो। तो ये सारे सवाल भी तुम्हारे लिए इक्वली रेलेवेंट है, ये सारे पेपर भी पुराने सालों के लिए तुम्हारे लिए इक्वली रेलेवेंट हैं। सो गाइज, बाकी अगर कुछ और भी लोगों को अगर डिस्कस करना होगा, जैसे कट ऑफ कितना जा सकता है, एग्जाम डेट कब है, कैसे तैयारी शुरू करें, डिफरेंट टॉपिक्स का वेटेज क्या रहेगा एग्जाम में, जो हमने मोटा मोटा बात कर लिया अभी, या सिलेबस में क्या करना है, सिलेबस के बारे में लोगों को काफी सारे डाउट होंगे, जैसे कि लेबर लॉज पढ़ना है नहीं पढ़ना है, या फिर आईएलओ में कन्वेंशन दिया हुआ 150 के करीब, कौन सी कन्वेंशन याद करनी है, जो सिर्फ इंडिया ने साइन किए हैं या सिर्फ कोर कन्वेंशन है, या क्या करना है। या जैसे सेकंड लेबर कमीशन का रिपोर्ट है 100, वो 1500 पेजेस का है, उसका क्या करोगे? 1500 पेज तो नहीं पढ़ोगे, एक सवाल आएगा अगर आएगा तो क्या करोगे? तो ऐसी बड़ी सारी चीजों के लिए हम एक डिटेल्ड सिलेबस एनालिसिस वाला वीडियो भी हम लोग यूट्यूब पे अवेलेबल करवाएंगे, उसको आप चेक कर लेना। एंड विद दैट नोट लेट्स स्टार्ट विद द पेपर। सो 2015 का पेपर फॉर हुम? फॉर लेबर एनफोर्समेंट ऑफिसर गाइड, जो कि ये पेपर लिखने वाले हैं, जो कि 2023 में जिसका होने का एक्सपेक्टेड है। सो लेट्स गेट स्टार्टेड।
Okay, starting with first question, which one of the following explanations is indicated by the term welfare as a total concept? Four of the options have been given. We need to identify which welfare connotes total concept, right? So if we go for A option, it is desirable state of existence involving physical, mental, moral, and emotional well-being. So if we go by logic, so total concept is reflected through this only, right? Okay, to elaborate on the other options which are given in the question, B option is saying it is the welfare of the man, his family, and community. So if we are talking about this concept, it is referring to social concept of welfare. C option, it is contingent upon time and space. So basically it is referring to relative concept of welfare. Fourth is saying it demands certain minimum acceptable conditions of existence biologically and socially. Then it means it is referring to positive concept of welfare. So accordingly, the option A is correct to this question. Question number 2, atonement and investment are two co-equal aspects of which one of the following labor welfare theory? So if we are talking about philanthropic theory, theory is saying that whatever welfare activities they are taken by the employers, it is due to affection for mankind, right? Placating theory, placating theory says that by doing various kind of welfare activities, we can please our workers, right? Public relations theory, according to this theory, any welfare act is done to create a good impression on the others or society. Religious theory. So this religious theory has two aspects, that is atonement and investment. So if we are talking about investment, aspect says that whatever is the fruits of today's deed, that will be reaped by any person tomorrow. Atonement aspect of the religious theory emphasize that whatever the present disabilities of the person, they are the results of the sins committed by the person in the past. Okay, so the answer to this question is D. Next, the first Factories Act for India was enacted in the year. Very simple, straightforward question. Many a times this question has been asked in various recruitment exams. That is, the answer to this question is 1881. That is B. Next question. Which one of the following statements with regard to provisions for welfare officer is not correct? First of all, the statement is given as the provision is given in the Factories Act 1948. So, of course, this statement is correct. This provision in case of mines and plantation is given in the central rules of these two acts, but not in the main act. So, these rules, while we are talking about this provision, while we are talking about Mines and Plantation Act, they are not contained in the main acts, but they are given in the central rules. Okay. Next statement. For factories and plantations, this provision is applicable when 500 or more workers are employed. So for factories, it is correct. But for plantation, this threshold is not correct. The correct threshold is correct threshold for minimum number of workers to have a provision for welfare officer is, that is 300 or more workers. Okay, so this statement is basically not correct. Fourth is, in mines, this provision is made applicable when 500 or more workers are employed. That is correct. Okay. Next. Which one of the following is not a welfare measure under the Factories Act 1948? So Factories Act 1948 contains detailed provisions with respect to health, safety and welfare that are contained in chapter 3, 4 and 5 of the Factories Act, right? So under these chapters we need to check that which provision is given under health, which is given under safety and which is given under welfare. So drinking water, basically it is not a welfare measure, it's a health measure which is given under the Factories Act. So the correct option to this question is A, right? Okay, so for crutches, what is the minimum threshold of workers? That is, if there are more than 30 women workers. First aid, one first aid is prescribed for every 150 workers. Canteen, it is prescribed wherein more than 250 workers are employed, right? Next question. Under the provisions of Maternity Benefit Act 1961, what is the amount of medical bonus paid? So this amount is 3,500. Okay. Amount of medical bonus is 3,500. Correct option is D. Under the Maternity Benefit Act 1961, what is the minimum number of days a woman employee must have worked under an employer in the 12 months preceding the date of expected delivery for becoming eligible for maternity benefit? So if one wants to avail the maternity benefit, how much minimum day of working is required on woman part? That is minimum of 80 days of working, right? So the correct option is B. Next. Under the provisions of Employees Compensation Act 1923, what will be the amount of compensation payable to an employee suffering from permanent total disability with his monthly salary drawn rupees 15,800 and the relevant factor is 181.37. So basically what information is given? So these kind of calculation based questions can be asked, but these are very simple. If one knows the provisions of the act, this amount is not difficult to calculate. Okay, so monthly salary is given as 15,800. So the act says even if you are drawing remuneration more than 8,000, we will be taking rupees 8,000 as base to calculate compensation. So earlier this limit was your 8,000. From January 2020, this wage ceiling limit of rupees 8,000 has been increased to rupees 15,000. So whatever is the amount of compensation, that would be computed on 15,000, right? Instead of 8,000. So in this case, the wage ceiling limit is 8,000, and then what we have to take, we have to multiply it with the relevant factor, and we have to compute the 60% of this amount, because in case of permanent total disability, the compensation is basically 60% of this amount. So this gives us 8,70,576. Okay, so in case of permanent total disability, either this compensation or rupees 1,40,000, whichever is more, that has to be paid by way of permanent total disability. Okay, so because this belongs to 2015, the calculation has been done on previous limit, not on the limit of rupees 15,000. Okay, so C is the correct answer. Next. Who among the following is not a dependent under the provisions of Employees Compensation Act 1923? A widower, an adult widowed sister. So again, if you do not know the provision, just go apply the logic. Widower, of course, they are under the dependent definition. Adult widowed sister, so far off relationships, they are not the dependent. adult widowed sister. So she got married, she then she became widowed. Okay, so she must be dependent on some other, on her deceased husband, right? Okay, so third option is a parent other than a widowed mother would be, of course, a father, a widowed daughter-in-law. So all three are dependent, are in the definition of dependent. So this B is the correct answer to this question. Okay. Next, who among the following is the ex officio chairman of the Medical Benefit Council constituted under the Employees Insurance Act 1948? So again a straightforward question wherein they are asking ex officio chairman of the Medical Benefit Council under the ESI Act. So for your information, whosoever is the Director General ESIC, he becomes the ex officio chairman, and Director General Health Service Government of India, he becomes the ex officio co-chairman. So the answer to this question is C. Director General ESIC becomes the ex officio chairman of the Medical Benefit Council formed under the Act, right? Okay. Under the provisions of the Maternity Benefit Act 1961, every woman employee after delivery of a child who returns to duty is to be provided with nursing breaks till the child attains the age of how many months? That is 15 months. So again a straightforward question which has been asked from maternity benefit. Okay, that is B. Option is correct. Which one of the following statements about industrial relations is not correct? First says industrial relations have to be managed in the interest of maintaining a viable collaborative structure. So logically this statement is correct. Formulation of rules by consensus and their implementation are core to industrial relations. Again, the statement is correct, logically correct. Pluralistic framework looks employee participation in industrial relations from a disintegrative perspective. So of course, pluralistic, those who follow the pluralistic approach to industrial relations, they believe that conflict is inevitable in any industry, right? Because of the disintegrative perspective of the workers and management. Okay, coming on to the fourth statement, the radicalist, who are the radicalist under this IR? That is Marxist, those who follow Marxist approach. They consider industrial relations in a distributive sense? No, basically Marxist people, they agree with the pluralistic approach. Besides agreeing to pluralistic approach, they were also of the view that conflict is not only inevitable, but at the same time conflict, apart from coming from the competing interests, they come from the inequality of the powers between the capitalist class and the workers class, right? So it becomes inevitable. At the same time, conflict arises due to the exploitation of the workers by the capitalist class. So that is why this statement is incorrect, right? Which one of the following is not a logic of industrial relations? So basically, if you are talking about logic of industrial relations, logic of industrial relation is a framework which is developed to understand the impact of the globalization on employment relations, and at the same time to predict the future trajectory of the employment relations, right? So according to logic of industrial relations, basically every employment relation in any country, in any nation, that is determined by the interplay of these three logics: logic of competition, logic of industrial peace, and logic of employment income protection. So statement A, that is not a logic of IR. Okay. What is a wildcat strike? Again, it's a very favorite question of the examiner, asked many times in recruitment test. Okay, so strikes called by the workers with the support of union. No. So wild cat. So you are going wild. It means you are not informing anyone, or you are not taking the approval of your union to which you belong before going on strike, right? So simply the correct option to this question is B. That is, it refers to a strike called by the group of workers on the spur of the moment without any formal notice to the employer and without any consent taken from the union. Okay. Next, which one of the following is a jurisdictional strike? So whenever we are talking about jurisdictional strike, jurisdictional strikes are conducted by the workers with a view to force an employer to recognize a particular trade union or to bargain with a particular trade union instead of others. So every leader tries to highlight their trade union in the eyes of the employer, that you must recognize our trade union for the purpose of bargain, right? Okay. So the correct option to this question is C. That is, it says two unions may claim to represent the same set of workers and may clamor for recognition on this claim. So they have a fight with respect to recognition of trade union in particular industry. Okay, clear? Next question. What is a yellow dog contract? So again, sometimes they do ask question from international industrial relations. Yellow dog contract, basically this term is used in America. Okay, and uh, however, what does it refers to? Basically, it refers to when management secures an agreement from the workman that he will not join a union during the course of his employment. So basically, there's an agreement between the new joinee and the management that you will not going to join any union during the course of your employment. So if you join, you will be fired. Okay. So this term was popularly used till 1932 in America, and it became illegal with the passing of Norris Law Rajya Act in America. It is no more there now. Okay. Next is the institution of voluntary arbitration as a method of settling industrial dispute was strongly favored by. So with voluntary arbitration, who is the person who is popularly associated? That is Guljari Lal Nanda. Okay, GL Nanda. He was also the Labor Minister of India in 1957 to 62, right? Okay, so during his tenure, when he was a labor minister, what was the basic points which were stressed upon? That we have to move away from legalism towards voluntarism. So go away from legalizing everything. So that is why the concept of model grievance procedure or recognition of unions or concept of joint management councils or voluntary arbitration came into picture. Okay, so the correct option is A, Guljari Lal Nanda. Industrial Dispute Bill 1947 observed that industrial peace will be most enduring when it is found on voluntary settlement. See, it is talking about Bill of 1947. How would we hit a correct answer? Look at the statement they are asking. This itself is giving you the hint. So, any industrial peace which is secured on voluntary settlement. Voluntary settlement means that there is no involvement of the third party. No third party intervention is there. So, which kind of provision would be recommended in this bill? Works Committee, Board of Conciliation, Court of Inquiry, Labor Court. So, Board of Conciliation, Court of Inquiry, Labor Court, all of them are under the powers of government, as well as they involve third party intervention. Only the Work Committee refers to voluntary settlement. So, surely the answer to this question is A, right? So, in this way, we can hit the correct answer. Next, in India, which one of the following systems prevails in respect of adjudication in industrial disputes? See, there are terms which are used in options: voluntary, compulsory, discretionary, right? So, which answer you will mark in such types of questions? First of all, because they are talking about in the second part, they are talking about acceptance of award. So which kind of acceptance of award and which kind of reference they are talking about. The nature of reference and nature of acceptance of the award has been asked in discussion. So if we talk about acceptance of the award, definitely they are not voluntary, but they are compulsory. So once they are issued by the appropriate forum, they becomes binding on the party. So it means these two options are overruled. These two options have to be set aside. Okay, regarding B and D, now whether it should be voluntary reference or discretionary reference. So if you go by layman language, there is very minute difference between voluntary and discretionary. If you're talking about discretionary, what do you mean by discretionary? Discretionary means whenever the authority thinks fit, whenever the authority thinks that it is rational to refer the dispute to the further authority, that becomes discretionary. Okay, based on his judgment. Okay, voluntary is out of his own will. He is not basing his decision on some judgment or on some rationality, right? So there's a very thin line between voluntary and discretion. So it is always discretionary reference based on his judgment. Whenever he thinks fit, whenever he thinks that the case should be submitted to the higher authority or the other authority, then the reference will be made. Okay, clear? So the answer to this question is D. Next, in India, which one of the following bodies was created particularly to focus on social and labor issues arising out of reforms of 1991? So if we have to talk about which committee was formed during 1991, that is Special Tripartite Committee, and it was formed by Ministry of Labor, and along with the focusing on social and labor issues during economic reforms, it also uh, emphasize on revival of sick industrial units. Okay, and references of the units to BIFR. Okay, so the correct option to this question is Special Tripartite Committee. Labor Management Relations Law consolidating the relevant laws be enacted. Go slow and work to rule be regarded as misconducts. Strike ballot for public utility services. And the last one is all the three methods of union recognition, namely membership, verification, secret ballot, secret ballot and check off be the basis for choosing a bargaining agent. So out of all these four options, the correct option is D, because this was not recommended by Second National Commission on Labor. Okay.
So the next question is, the view that people can learn through observation and direct experience is associated with which one of the following theories of learning? So the options are social learning, operant conditioning, reinforcement, and classical conditioning. All right. So there are two words which makes the answer very clear, which is observation and direct experience. So let us do this question maybe by elimination if you don't know the answer correctly or directly. So what is classical conditioning? It basically has a relationship in stimulus and response. All right. So it is not related to observation or direct experience in any way. Reinforcement is basically actions are maybe they are reinforced positively or negatively, or sometimes punishment is given. All right, so this is also not related to the question being asked. Operant conditioning includes rewards and punishment based on the behavior of the person. All right, so last but not the least, this is social learning, and which is also the correct option. What is social learning? It is also known as observation learning. If you know its another name, you can actually mark the answer within 2 seconds. All right, so social learning, it was basically given by Albert Bandura, and it just says that people learn by while observing others and by having a direct experience of observing the actions and behaviors of other people. Very small and a basic example is how children learn by observing their parents. All right, so the correct answer is social learning. All right, the next one. Employees' belief in the degree to which they affect their work environment, their competence, the meaningfulness of the job, and their perceived autonomy in their work indicates what? Organizational commitment, psychological empowerment, affective commitment, or job satisfaction. Here, the correct option is psychological empowerment. Why? Because the question actually is asking about the employee's belief. All right. in his or her work environment, their competence and the meaningfulness of the job, how meaningful the job is for themselves. All right, so it is, first of all, it is not asking about only the organization, how committed the employee is about the organization or for the organization. So this is an incorrect option. Affective commitment is the commitment which is related to the feelings and emotions of the employee. So given the question statement, this is also not suitable and not even this job satisfaction option. So psychological empowerment, if you go go to attempt the question by elimination method, also you can attempt it. Otherwise also psychological empowerment basically is where people are psychologically empowered. They are called as psychologically empowered when they actually have a sense of meaning in their lives, meaning in their jobs, all right, and when they develop a sense of confidence. They have a sense of confidence, they have a confidence in their competence, their capacities, all right. So the correct answer for this is psychological empowerment. When the employee is feeling psychologically empowered, he would have a belief in his or her work environment, the competence and the meaningfulness of the job itself. All right. So the correct answer is option number B. Next question. The tendency of individuals to attribute their success to internal factors and put the blame for failures on the external factors indicates, very simple one, it is self-serving bias. Now, you may have a confusion of this option with fundamental attribution error. Fundamental attribution error is actually opposite to the self-serving bias. See, the question is saying that individuals attribute their success to their internal factors. But what happens in fundamental attribution error? In case of other beings, all right, if I am considering one of my friends and I say that his or her success depends upon his or her internal factors rather than the external factors. So what is basically happening here is, for my own success, I credit myself, my internal factors for that, but for others, I am contributing or attributing their success to some external factors and their failures to their internal factors. So this is the basic difference between the fundamental attribution error and the self-serving bias. Now, what is selective perception? Selective perception is basically interpreting any behavior or any events based upon their own experiences or backgrounds. So this is incorrect, obviously. What is contrast effect? Contrast effect is basically when a person is compared and his or her characteristics are analyzed based on the comparison with some another human being. So this is also an incorrect answer. So the correct answer is self-serving bias. All right. Self-serving means they are serving themselves by telling themselves that, oh, I got failed in this this exam maybe because of the external factor, because exam was too tough in that case. So, and if I succeeded, so I will say that, oh, I have done a lot of hard work, so I succeeded in that. So basically, I'm serving myself. So this is self-serving bias. Next question. Intuitive decision making means, see, as the name only is suggesting, what is intuitive? Intuitive is based on intuition, or you can say in common parlance as sixth sense. All right. So basically, it is opposite to rational decision making. Now, which of the options is actually, communicating that intuitive factor? See, a non-conscious process, yes, it is doing that. Making decisions by constructing simplified model, no, this is actually making a kind of rational decision. Behaving in such a way as to maximize output, obviously this would also make count for some of the rational decision. Developing alternatives consciously is not intuitively. So the correct answer is a non-conscious process created out of distilled experience. All right. So 25th answer is A. Next question. A group whose efforts result in performance that is greater than the sum of the individual inputs is called. All right. Now, see, two options you can easily eliminate, which is a virtual team. That is the team which is working on internet or in a virtual space. All right. Self-managed groups, the groups which work without any kind of supervision. This is the basic meaning of these two options. So these are not related to what the statement says in the question. Now, you may get confused between work group and work team because the question is using the term group. So you do not have to get confused with it. And the correct option is option number B. I'll tell you why. See, what is a work team? Work team is where the goals are shared, the responsibility and the accountability is individual as well as mutual. So in a team, the accountabilities are shared, the goals. In work group, what happens is there is individual independence. All right, the people are actually independent of each other and they have individual accountabilities. So you cannot say that the performance can be greater than the sum of the individual inputs. Why? Because there in the work group, it is all individually acting people and all have individual accountabilities. In work team, it is somewhat different, which is there are what we say shared group goals and shared accountabilities. So the correct answer is B, work team. All right. Next question. The concept that a subordinate should have only one superior to whom he or she is directly responsible is known as. See, no need of any discussion in this question. The answer is unity of command. One subordinate, one superior. All right. This is the option number B. Next question. Which one of the following appraisal methods combines the benefits of narratives, critical incidents, and quantified scales by assigning scale points with specific examples of good or poor performance? All right. If you have read carefully about the 5 steps given in the behavioral anchored rating scale, you would in one go mark option C as the correct option. All right. It basically has 5 steps, this scale, which includes generating critical incidents. Next, this is the 4 steps. Next, second step is developing performance dimensions. All right. The third one is relocating incidents. The fourth one is making or preparing a scale of incidents. And last is development of final instrument. All right. So if you know these steps clearly, if you know that there is incidents always being used, critical incidents is being used in the behaviorally anchored rating scale, you will be easily able to mark option C as the correct answer. All right. Other options are clearly, not related to post distribution, alteration, ranking, graphic rating scale. These are all very different from the question given. Actually, I would rate it as a very easy question because clearly the keywords are given from which you can pick the correct answer in one go, like without wasting any time. All right, the answer is C. Next question. Which one of the following demographic characteristics reflects surface level diversity? Now understand what is a surface level diversity. Surface level diversity is basically refers to easily detectable, or we can say the readily detectable attributes such as the gender, the age, the ethnicity, or the religion, etc. All right, this is the kind of surface level diversity. Surface level means readily detectable features of the diversity. All right, this is also known as demographic diversity and social category diversity. Also, it is known as biodemographic diversity. All right, so there are various kind of names for this kind of diversity. So by knowing about what actually is it, the features such as age, gender, ethnicity, religion. So what is the correct answer for this? Obviously, ethnicity. All right. So here you do not have to even read the other options if you are very well aware of the surface level diversity, because even in other things diversity as a factor is there, but because it is clearly related, the question is given the demographic characteristics. So what is actually included in demographics? This is all these things, and ethnicity is the correct answer. All right. A SMART mnemonic criterion is used in, very easy one. I hope everyone knows about it. Selection process, job rotation, performance management, or compensation management. It is performance management. Here, SMART refers to what? SMART is all related to the goals or the targets of the employees. It is basically the targets must be specific. M related to that the targets must be measurable. A related to they must be achievable, that is they must be rational enough, then they must be realistic enough. All right, and finally T, that is time bound. That is targets must be completed within a given time frame. So this is SMART. So all of these parameters helps in judging the performance of the employees, and then it is helpful in the performance management. So the answer is C for this. All right, next question. Outplacement is the process of outplacement. The term itself is giving you a clear hint. Outplacement is placing somebody outside the organization. All right. So it is actually the option actually is helping redundant employees to find a new job. Now see what happens when a company is actually downsizing. All right, they use outplacement as a strategy where they assist the employees who are being terminated to find new jobs in the outside market. Because of some reasons they are downsizing, or they are eliminating some of their employees, maybe because of some financial factors, or maybe there is a change in technology where the manpower is less needed. So these are the various factors for downsizing, and what happens is after that is when the company is actually generous enough, they will provide the employees outplacement. All right, so the correct answer is C, helping redundant employees to find new job. Next question. The principles of natural justice have emanated from. Now, this is a very important topic, natural justice. All right. I hope everyone is aware of that natural justice actually came from the term jus natural. That means law of nature. All right. It is basically the idea of the common, or we can say the usual day-to-day life, day-to-day law, basically. All right. So these actually simply establish a difference. The principles of natural justice basically establishes a difference between what is right and what is wrong. And it also implies that natural justice basically relates to what is fair, what is how is equality being, how is reasonableness being maintained in various kind of decisions. All right, this is basically concentrated upon the natural human rights. So it is also called as principles of natural justice. So the correct option here is common law. All right, now I would like to tell you one more thing about it, that there are two basic rules of natural justice, or we can say the two basic principles of natural justice. Number one is rule of fair hearing. We call it odi altrum partum. This is the rule of fair hearing. That is, everyone should have a right to be heard. All right. Next is nemo judex in causa sua. This is rule against bias, or we also call it as that no one should be the judge in his or her own case. Why? Because otherwise there would be a factor of biasness if you are being made a judge of your own case. So these are the two basic principles of natural justice. And just very easy question, because this is not constitution law, this is not about social norms, not about religious doctrines. So the correct answer is common law. It was made for common people and the common natural human rights. All right, answer is C. Next one. If an aggrieved employee is not satisfied with the proceedings of the inquiry, he may ask for A, ex parte inquiry, de novo inquiry, legal inquiry, or domestic inquiry. See, legal and domestic inquiries are not related at all to the question. It is, the correct answer is de novo inquiry. De novo inquiry is basically inquiry done afresh. Okay. Inquiry done afresh. See, if in case the previous inquiry was not it was not completed properly, or it was not conducted properly, the court on request of the aggrieved individual can ask the competent authority to re-inquire the whole method. So in that case, de novo inquiry is the correct answer. What is the ex parte inquiry? See, when an officer, it is the inquiry done in case an officer is absent from the duty, like for a long time without any intimation given, and his or her movements are also not known. So in that case, ex parte inquiry is done. So this is not related to the question. So we are left with option number B, and you must know that it is the inquiry done afresh. If the employee is not satisfied with the previous inquiry, he can ask for another inquiry only if the court permits for that. All right. Option number B is the correct answer. Next is, in case of disciplinary action, the principles of natural justice have given rise to which one of the following procedural safeguards? See, if you go by the normal basic common sense, also you can mark this question as correct. Let me tell you the correct option, which is charge sheet. Charge sheet is what? Basically, after the preliminary inquiry, when a charge sheet is made, the charges are being jotted down, and after that, charge sheet is basically a preliminary process only before declaring a person as actually the criminal or the default or offender in that case. So charge sheet basically, after being formed, gives a right or gives a chance to the person who is being pointed out, that he or she can actually have the chance to explain themselves, to give or to put forth the explanation that why and why not they can be charged as guilty. So this is basically giving them a chance of hearing. And chance of hearing is odi alterum partem, that I told you already in natural justice, the principle of natural justice. So charge sheet is basically the what we say, the right or being heard. All right, so this is the answer for this, which is charge sheet. All right, next question. See, again, odi alterum partem, to which of the following is it associated with? Strikes, disciplinary action, trade union, or closure? Very easy one. It is disciplinary action. Whenever a disciplinary action is taken, then the other party, the aggrieved person, is actually given a chance of being heard. Then it is the correct option, which is disciplinary action. All right.
Under the provisions of TU Act, Trade Union Act 1926, what is the maximum time period for which the members of the executive and other office bearers of the trade union shall be elected? Simply, the answer to this question is 3 years. Very simple question, straightforward from the Act. That is 3 years. Under the provisions of the Trade Union Act 1926, what is the minimum amount of subscription that can be fixed for the members of the trade union of the rural workers? Because they are talking about money threshold with respect to workers. Again, the threshold is kept at very low side. Okay, so if we are talking about subscription of rural workers, it is mentioned that is 1 rupee per annum. And if you are talking about workers which are belonging to unorganized sector, what is the quantum of subscription? That is 3 rupees per annum. And in other cases, it is prescribed 12 rupees per annum. So the correct option, because they are referring to rural workers, the correct option should be 1 rupee per annum. Under the provisions of Trade Union Act 1926, ordinarily, what is the minimum age of a person that should have been attained to become a member of RTU, Registered Trade Union? So simply, the answer to this question is 15 years. So to become a member of Registered Trade Union, one should attain the age of 15 years. And to become an office bearer, the person should not be less than 18 years old, right? Next, under the provisions of Trade Union Act 1926, what is the minimum number of members engaged in the establishment as workmen required for registration of a trade union? Again, this is very simple, straightforward question. So what is the minimum threshold which is prescribed for registration of a trade union? That is 7. 10% or 100 workmen subject to minimum of 7. So the correct option is A. Which one of the following can be considered as a precursor of trade union movement in India? So the precursor which is considered for trade union movement in India is this Bombay Mills Hand Association. So the answer to this question is C. So one may even mark Madras Labour Union, but that would be a incorrect answer. Madras Labour Union, no doubt, that was the first registered trade union, but that did not serve as a precursor to trade union movement in India. So the correct option is C, Bombay Mill Hands Association. Next. So this is a repeat question which has been asked in 2017 exam also. Same question has been asked. They are asking you to arrange these trade union federations starting from the earliest. Okay. So if we have to talk about AITUC, it came in 1920, All India Trade Union Congress. INTUC, it came in 1947, Indian National Trade Union Congress. Then came Hind Mazdoor Sabha, 1948. Then BMS, that came in 1955. BMS stands for Bharatiya Mazdoor Sangh, and CITU stands for Center of Indian Trade Unions, that came in 1970. So the correct option is B, that is AITUC, INTUC, HMS, BMS and CITU. Right. Next. Who among the following was the first president of All India Trade Union Congress? So first president was Lala Lajpat Rai. The correct option to this question is D. Which one of the following statements with regard to Council of Indian Employers is not true? Okay, so they are basically referring to the question of trade unions of employers. So it was formed in the year 1956. One must be aware of this thing. Yes, it unified. So what was the purpose for which it formed? It was formed for this purpose. The purpose which is stated in option B, that is unifying all India Organization of Employers and Employers Federation of India. So again, this is a true statement. The Standing Conference on Public Enterprises has not joined the CIE. This is a wrong statement because the Standing Conference on Public Enterprises, which is acronymed as SCOPE, it joined Council of Indian Employers in the year 1973. Okay, so the fourth statement is also correct to this question. Okay, the correct the correct answer to this question is C, which means statement C is incorrect. Next question. Under the provisions of Industrial Dispute Act 1947, the average pay for a monthly paid workman means the average of the which of the following? So ID Act basically provides the definition of average pay, wherein it says in case of monthly paid, we need to take the average of 3 complete calendar months. In case of weekly paid employees, we need to calculate the average pay on the basis of 4 complete weeks. And in case of daily paid workmen, we need to take the average pay based on 12 full working days. So accordingly, the correct option to this question is B, because they are asking you monthly paid workmen. So it is based on the wages payable in 3 completed calendar months preceding the date on which the average pay becomes payable. Right? Next. What is the time period within which the Grievance Redressal Committee, constituted under the provisions of the Industrial Dispute Act 1947, is to complete its proceedings on receipt of a written application by or on behalf of a aggrieved party? So simply these provisions of Grievance Redressal Committee, they were introduced in the Industrial Dispute Act in 2010, and the period which is prescribed is 30 days. So they need to complete their proceedings within 30 days on receipt of a written application by or on behalf of the aggrieved party. Okay. Next is, which one of the following statement as per the Industrial Dispute Act 1947 is not correct? Court of inquiry is constituted by the appropriate government. Yes, this is correct. Conciliation officer for conciliating industrial disputes in central government public sector undertakings are appointed by the central government. Because they are talking about central government public sector undertakings, based on the definition of appropriate government, we may infer out of this thing that they would be appointed by the central government. National tribunal is constituted by both the central government and state government. So this is incorrect statement, because national tribunal have to be appointed by central government only. For which matters? For matters involving question of national importance, and for those matters which involve industrial establishments situated in more than one state, they are likely to be get affected by those matters. Okay, so central government only has the jurisdiction to appoint national tribunal. So C statement is incorrect. So answer is C. Under the provisions of Industrial Disputes Act 1947, what is the time period within which the appropriate government has to publish the award? So what is the time period stipulated to publish the award? That is 30 days. Okay, simple, straightforward question. Under the provisions of Industrial Dispute Act 1947, which one of the following is considered to be retrenchment? So this is again very important definition which is given under the ID Act, retrenchment definition. Again, the exclusive and inclusive parts they are asking in the options. So retrenchment is at any termination of services, but ID Act specifically provides that following will not be considered as retrenchment cases. What are those cases? That is voluntary retirement of workmen. So if they are voluntarily retiring, it means their services are not terminated. So this is again all logical. Termination of service on the ground of ill health. So if you are terminating any employee because he is not well, then that is also not retrenchment. Next is termination of service of the workman as a result of non-renewal of the contract of employment. So if the contract between the employer and the workman that did not get renewed, then that means that does not amount to termination by way of retrenchment. So only thing left is this termination of service of the workman. Yes, retrenchment includes termination of service of the workman, otherwise then as punishment inflicted by way of disciplinary action. It means this is also the exclusion of the retrenchment definition. So if you are terminating the employee out of some disciplinary action, then that also does not amount to retrenchment. Okay, although this part is termination of service of the workman. Okay, so B is the correct answer to this question. Under the provisions of ID Act, what is the time period within which if no communication has been received by the employer in response to his application to the appropriate government for retrenchment of the workman, then it will be deemed that permission for retrenchment has been granted. So basically there are two chapters, chapter 5A and chapter 5B under the ID Act, wherein provisions related to layoff, retrenchment and closure have been prescribed. So under chapter 5A, more general provisions are given, and it is applicable to those industrial establishments which are employing 50 to 99 workmen, whereas chapter 5B is applicable to those industrial establishments which are employing 100 or more workers. So basically chapter 5B is applicable to bigger industrial establishments. That is why more stringent provisions are contained in chapter 5B. So this is the basic distinction between chapter 5A and 5B. So don't forget this. Okay, so under chapter 5B, you need to seek the permission for resorting to layoff, retrenchment or closure. Whereas in chapter 5A, there is no such seeking of permission is required. You need to inform to the government by way of notice. So if we are taking the permission, then only the provision with respect to deemed permission would be applicable, right? And what is the threshold by which the permission should be given by the appropriate government? Otherwise, it would be amounted to as deemed permission, that is 60 days. 60 days. Okay, so it is clearly mentioned in chapter 5B. The term protected workman is defined in which of the act? So these kind of definition, these kind of questions are also there, that which definition is given in this. So you have to pay attention to the unique definitions which are not included in any other act, right? So Industrial Dispute Act 1947 basically. So if you go by logic also, ID Act, because it is referring to the disputes in between employer and workmen, so some protection would be talked about in ID Act. Okay. So although it could have been under Trade Union Act also, so more specific act would be Industrial Dispute Act, right? Okay, fine. So if we go by the provision of the act, how much is the threshold for workers to be recognized as protected workmen? That is 1% of the total number of workers, subject to minimum of 5 and maximum of 100. Okay. So the correct option to this question is B. Which one of the following statement explains that a strike is legal under the provisions of ID Act? So which statement says that strike is legal? So if you go by B and C statement, a strike declared during the pendency of conciliation proceedings and 7 days after the conclusion of the such proceedings. So that is prohibited. Again, C option, a strike declared during any period in which settlement or award is in operation. Again, this is prohibited. No strike or lockout can be done during such periods. If you go by statement A, a strike declared in consequence of an illegal lockout. Okay, so that is legal. So if your employer is resorting to illegal lockout, any strike done by the workers thereafter as a consequence of that illegal lockout, that is considered as legal. Okay, so statement A is correct. The provisions of the Payment of Wages Act 1936 shall be made applicable to an employed person drawing a monthly wages not exceeding how much amount? So quantum of wages they are asking, based on which Payment of Wages Act is applicable to a particular person. So earlier this limit was 18,000. So okay, however in 2017 this threshold got changed to 24,000 per annum. So now Payment of Wages Act is applicable to persons who are earning wages up to rupees 24,000. So because it's a 2015 paper, the threshold till then was 18,000. Okay, accordingly the answer is A. Next question is, under the provisions of Payment of Wages Act 1936, the total amount of fine that may be imposed in any one wage period. See again the repeat question. So 2017, 2015, same question has been asked. What is the maximum amount of fine that can be imposed on any worker? That is 3% of the wages. So C is the correct option, right? Under the provisions of Payment of Wages Act, no fine shall be imposed on any employed person who is under the age of 15 years. Straightforward questions from the provisions of fines under the Payment of Wages Act, right? So correct option is A. Again, under the provisions of Payment of Wages Act 1936, fine imposed on any employed person cannot be recovered after expiry of how many days from the day it was imposed? That is 90 days. Okay, fine. So if the 90 days from the day on which the fine is imposed, they expire, no one can recover fine. Okay.
Under the provisions of this act, which is Wages Act, which one of the following is a component of wages? तो यहाँ पे हमें 4 ऑप्शन दिए हैं और हमसे पूछा है कि कौन सा कंपोनेंट है. तो वेजेस का आपको कॉलम मिलेगा डेफिनेशन के सेक्शन में, which is always section 2. ठीक है. तो वैल्यू ऑफ हाउस अकोमोडेशन, नो, इट इज नॉट अ कंपोनेंट ऑफ वेजेस. वैल्यू ऑफ मेडिकल अटेंडेंस, अगेन नो. Traveling allowance, no. House rent allowance, yes. House rent allowance is the correct answer, and therefore correct answer is option D. ठीक है. Next question. What is the extent of representation of independent persons in the committee and subcommittee constituted under the provisions of Minimum Wages Act 1948? तो basically committees और subcommittees और advisory board central and both state बनते हैं क्यों? ताकि वो appropriate government को advise कर सकें for fixing the minimum wages. ठीक है, तो उस कमेटी में जो इंडिपेंडेंट मेंबर्स होते हैं दे कैन नॉट बी लेस देन 1/3 ऑफ द टोटल नंबर ऑफ मेंबर्स। ठीक है, करेक्ट आंसर इज ऑप्शन सी। नेक्स्ट क्वेश्चन, under the provisions of minimum wages act, which one of the following body is appointed by AG, appropriate government is A.G, for the purpose of coordinating the work of these committees and advising this? तो वो कौन है? So that committee is advise that particular body is advisory board. Okay, so correct answer is option B. But if you go more, you will find out that to coordinate the work of advisory board, it is central advisory board, right? But for this question, correct answer is advisory board. So B. Next question, under the provisions of minimum wages act, who among following cannot be appointed as the authority by the appropriate government to hear and decide any claims arising out of payment of less wages? तो अथॉरिटी कौन नहीं हो सकता? तो सेक्शन 20 हमको प्रोवाइड करता है कि क्लेम के लिए असिस्टेंट लेबर कमिश्नर कैन नॉट बी एन अथॉरिटी. हु कैन बी एन अथॉरिटी? लेबर कमिश्नर ऑफ अ स्टेट गवर्नमेंट, रीजनल लेबर कमिश्नर सेंट्रल, कमिश्नर फॉर वर्कमैन्स कॉम्पनसेशन विच इज अपॉइंटेड अंडर एम्प्लॉय कॉम्पनसेशन एक्ट. तो ये जो है ये आपका क्या कहते हैं क्लेम के लिए अथॉरिटी हो सकता है. ठीक है, तो करेक्ट आंसर इज ऑप्शन डी. नेक्स्ट क्वेश्चन, अंडर द प्रोविजंस ऑफ कॉन्ट्रैक्ट लेबर रेगुलेशन एंड अबॉलिशन एक्ट, हाउ मेनी मेंबर्स में बी नॉमिनेटेड बाय सीजी व्हाइल कॉन्स्टिट्यूटिंग द सेंट्रल एडवाइजरी बोर्ड? ठीक है, तो कितने मेंबर नॉमिनेट किए जाते हैं? तो बेसिकली चेयरमैन होता है, ठीक है, सीएलसी होता है एज एन एक्स ऑफिशियो, और not exceeding 17 but not less than 7 members, not less than 11 members जो है वो nominate किए जाते हैं. And these people are from various representations. They may be from railways, they may be from mining, they may be from employer representation, employee representation. And one important point, it can never be possible that employee representation is less than employer representation. So always employee representation is always equal to or greater than employer representation. ठीक है, तो करेक्ट आंसर इज ऑप्शन ए. नेक्स्ट क्वेश्चन, अंडर द प्रोविजंस ऑफ कॉन्ट्रैक्ट लेबर रेगुलेशन एक्ट, अ कॉन्ट्रैक्टर हैज टू प्रोवाइड एंड मेंटेन अ कैंटीन वेयर इन ऑनरी अ मिनिमम नंबर ऑफ 100 कॉन्ट्रैक्ट वर्कर्स आर एम्प्लॉयड बाय अ कॉन्ट्रैक्टर. अगर मिनिमम 100 मेंबर्स एम्प्लॉयड हैं तो कैंटीन होना मैंडेटरी है. तो करेक्ट आंसर इज ऑप्शन बी. ठीक है, आगे बढ़ते हैं. Which of the following provision is not covered under Contract Labor Regulation Act? ठीक है, तो कौन सा provisions covered नहीं है? तो sufficient supply of wholesale drinking water covered है, restroom covered है, first aid facilities covered है, creches are not covered. So correct answer is option D. ठीक है, हम आगे बढ़ते हैं. Under the provisions of Contract Labor Regulation and Abolition Act, which one of the following statement is true relating to the appointment of chairman of state advisory board? ठीक है, state advisory board का जो chairman है इसको कौन अपॉइंट करता है? इसको स्टेट गवर्नमेंट अपॉइंट करती है. तो ये करेक्ट है. लेबर कमिश्नर ऑफ द स्टेट शैल बी द एक्स ऑफिशियो चेयरमैन. नो, एक्स ऑफिशियो मेंबर. ठीक है, द चेयरमैन इज टू बी अपॉइंटेड बाय द स्टेट गवर्नमेंट इन कंसल्टेशन विद द सेंट्रल गवर्नमेंट. देयर इज नो रिक्वायरमेंट ऑफ कंसल्टेशन ऑफ सेंट्रल गवर्नमेंट. सो दिस इज इनकरेक्ट. लेबर मिनिस्टर ऑफ द स्टेट शैल बी द एक्स ऑफिशियो चेयरमैन. अगेन रॉन्ग. करेक्ट आंसर इज ऑप्शन ए. Under the provisions of Child Labor Prohibition and Regulation Act, the Child Labor Technical Advisory जो कि सेक्शन 5 के अंतर्गत बनती है, consist of a chairman and such other matter not exceeding कितने 10. ठीक है, तो करेक्ट आंसर इज ऑप्शन बी. ये कमेटी क्यों बनती है? ये कमेटी का पर्पस होता है सो दैट अगर जो शेड्यूल है जिसमें वो एम्प्लॉयमेंट है जहां पे प्रोहिबिशन है फॉर द वर्किंग ऑफ अडल्ट्स एज वेल एज चाइल्ड, उनमें अगर कोई प्रोफेशन ऑक्यूपेशन ऐड करना है या कोई प्रोसेसेस ऐड करनी है तो उसके लिए इस कमेटी के थ्रू वो काम होता है. ठीक है, आगे बढ़ते हैं. अंडर द प्रोविजन ऑफ चाइल्ड लेबर प्रोहिबिशन एंड रेगुलेशन एक्ट, लिस्ट ऑफ ऑक्यूपेशन इन विच चिल्ड्रन आर प्रोहिबिटेड टू बी एम्प्लॉयड इज प्रोवाइडेड अंडर, ये प्रोवाइड करा गया है पार्ट ए ऑफ शेड्यूल अंडर द एक्ट. तो चाइल्ड प्रोहिबिशन एक्ट में दो पार्ट हैं विच इज पार्ट ए एंड पार्ट बी. ठीक है, हजार्डस प्रोसेसेस एंड द ऑक्यूपेशंस पार्ट ए में दिया हुआ है जहां पे अडोलसेंट और चाइल्ड बोथ आर नॉट अलाउड टू वर्क. एंड पार्ट बी में वो फैमिली या फैमिली एंटरप्राइजेस दिया है जहां पे चाइल्ड एज अ हेल्पफुल भी नहीं, एज अ हेल्पर भी नहीं काम कर सकता है. ठीक है, आगे बढ़ते हैं. विच वन ऑफ द फॉलोइंग इज टू बी कॉन्स्टिट्यूटेड अंडर द प्रोविजन ऑफ दिस एक्ट? ओके, अभी हमने इसकी बारे में बात करी. सो दिस इज चाइल्ड लेबर टेक्निकल एडवाइजरी कमेटी विच इज ऑप्शन बी. सो करेक्ट आंसर इज ऑप्शन बी. Next question, which of the following is not correct under the provisions of Child Labor Prohibition and Regulation Act? तो इसमें section 7 I guess part 3 में पार्ट 3 में जो है वो रेगुलेशन ऑफ कंडीशंस प्रोवाइड करी गई हैं, और इसमें दिया है नो चाइल्ड शैल बी परमिटेड टू वर्क, ये करेक्ट है। द टोटल पीरियड ऑफ वर्क इंक्लूडिंग द इंटरवल फॉर रेस्ट शैल नॉट स्प्रेड ओवर मोर देन 6 आवर्स, ये अगेन करेक्ट है। अ चाइल्ड में बी परमिटेड टू ओवरटाइम वर्क बट मैक्सिमम फॉर 2 आवर्स इन अ डे, नो, नो ओवरटाइम अलाउड फॉर अ चाइल्ड, नो ओवरटाइम अलाउड, ठीक है। नो चाइल्ड शैल वर्क फॉर मोर देन 3 आवर्स बिफोर ही हैज एन इंटरवल फॉर रेस्ट एट लीस्ट 1 आवर, ओके, अगेन ये भी सही है, सो करेक्ट आंसर इज ऑप्शन सी। आगे बढ़ते हैं। अंडर द प्रोविजंस ऑफ पेमेंट ऑफ ग्रेच्युटी एक्ट एन एम्प्लॉयर इज लायबल टू पे द अमाउंट ऑफ ग्रेच्युटी, कितने दिन में? 30 डेज में, सो बी इज द करेक्ट आंसर। Next, under the provision of this act, what is the maximum amount of gratuity payable? तो maximum amount of gratuity जो है वो actually 20 lakhs है, पर यहाँ पे एक पॉइंट है कि ये पेपर जो है ये 2015 का है, और 2018 के अमेंडमेंट के बाद जो अमाउंट था वो 10 लाख से 20 लाख बढ़ा दिया गया। सो यू विल फाइंड ऑन, जब आप खुद ही आंसर ढूंढोगे, यू विल फाइंड दैट द करेक्ट आंसर गिवन वाज 10 लाख, बट फॉर अ कंटेम्परेरी टाइम पीरियड व्हिच इज 2022, करेक्ट आंसर इज ऑप्शन सी। ओके, नेक्स्ट, under the provisions of gratuity act, who among the following is not the part of a family of a male employee? Okay, तो ये लॉजिकल क्वेश्चन है, अगर आप इसको पढ़ोगे भी सेक्शन 2 डेफिनेशन में, फैमिली की डेफिनेशन काफी लॉजिकल होती है हमेशा। हिज चिल्ड्रन वेदर मैरिड और अनमैरिड, यस, बात सही है। चिल्ड्रन ऑफ हिज प्री डिसीज डॉटर, ओके, तो उनके उसके चिल्ड्रन के लिए अब कौन जिम्मेदार होगा? द फादर ऑफ दोज चिल्ड्रन, सो देयरफॉर द लायबिलिटी ऑफ ग्रेच्युटी शिफ्टेड टू द फादर एंड नॉट द ग्रैंडफादर, ओके, नाना जी पे नहीं आएगी। सो इसलिए ये इनकरेक्ट आंसर है, डिपेंडेंट पेरेंट्स करेक्ट, डिपेंडेंट पेरेंट्स ऑफ हिज वाइफ, सो करेक्ट आंसर इज ऑप्शन बी। Okay, under the provision of this act, what is the minimum period of services of an employee must have served to make him eligible for a gratuity for his or his retirement or resignation? तो ये टाइम पीरियड है minimum of 5 years. Hence correct answer is option B. हम आगे बढ़ते हैं। Under the provisions of Building and Other Construction Workers Act, employment of how many female construction workers makes it mandatory for providing creche facilities? So correct answer is option D, which is more than 50. तो क्रीशे फैसिलिटीज क्या होती हैं? जो भी टॉडलर्स होते हैं या फिर जो छोटे से बच्चे होते हैं 6 साल से कम की एज के, उनके लिए एक तरीके से एरिया जहां पे वो रह सकते हैं एट द वर्किंग प्लेस, ठीक है। सो करेक्ट आंसर इज ऑप्शन डी। आगे बढ़ते हैं। Which of the following is not a statutory provisions under Building and Other Construction Workers Act? तो कौन सा statutory provisions नहीं है? ठीक है, तो ड्रिंकिंग वाटर प्रोवाइड किया गया है, अकोमोडेशन प्रोवाइड किया गया है, लैट्रिन यूनिट्स प्रोवाइड किया गया है, बट नॉट सच फैसिलिटीज ऑफ रेस्ट रूम एंड लंच रूम को ऐसा कोई प्रोविजन नहीं है, इसलिए करेक्ट आंसर इज ऑप्शन डी। ओके, पढ़ते हैं आगे। अंडर द प्रोविजंस ऑफ बिल्डिंग एंड अदर कंस्ट्रक्शन वर्कर्स एक्ट, द एम्प्लॉयर ऑफ एन एस्टेब्लिशमेंट हैज अ सेफ्टी ऑफिसर इफ देयर आर कितने 500 और मोर वर्कर्स। तो जब 500 या 500 से ज्यादा बिल्डिंग वर्कर्स हैं तो एक सेफ्टी कमेटी बनती है, एक सेफ्टी ऑफिसर अपॉइंट होता है, ठीक है, इसलिए करेक्ट आंसर इज ऑप्शन ए। हम आगे बढ़ते हैं। अंडर द प्रोविजंस ऑफ बिल्डिंग एंड अदर कंस्ट्रक्शन वर्कर्स एक्ट, अ बिल्डिंग वर्कर हु हैज बीन रजिस्टर्ड एज अ बेनिफिशियरी कैन कंट्रीब्यूट टू द फंड क्रिएटेड अंडर द एक्ट टिल ही अटेन द एज ऑफ हाउ मच 60 इयर्स। सॉरी, ये गलत बता दिया मैंने, 60 इयर्स, ऑप्शन बी, यानी 18 से 60 साल के बीच में वो कर सकता है, बेनिफिशियरी के लिए अप्लाई कर सकता है, ठीक है, और प्रीसीडिंग उसने 12 मंथ्स में 90 या 90 डेज से ज्यादा काम किया है। तो ये कुछ क्राइटेरियाज होते हैं।
Now, question number 76, or the next question. Under the fundamental rights in the Constitution of India, right to religion is not restricted by which of the following? Public order, morality, health, to acquire and administer property. See, fundamental rights are said to be qualified and not absolute. All right, that means that they always have reasonable restrictions attached to them, and it means that no right is such that everyone can take advantage of that right in full form. There are certain restrictions. So the question is asking that kind of restrictions with relation to rights to religion. So what all are there for religion? It is public order, morality and health, plus other provisions in the Constitution. This is being written. All right. So these three are there, and the question is asking about not restricted by. So the correct answer is option number D, which is to acquire and administer property. Next question, right to privacy is an implied fundamental right traceable to which of the following articles? All right, let me tell you that the right to privacy was made a fundamental right under the judgment of S. Puttaswamy versus Union of India in 2017 case. Now, the right to privacy was being declared as a fundamental right by Supreme Court under this judgment, and finally the right to privacy was put under article number 21, which is right to life and personal liberty. So the correct answer is D. Next question, who appoints the judges of High Court of a state? Now, who is in charge of appointing the judges of the High Court of a state? Basically, they have asked only one person. Otherwise, also, let me tell you, the correct answer, first of all, here is President of India. Now, he not alone can decide about the appointment of judge of the High Court. Basically, who is the President is actually the final authority, but he consults with the Chief Justice of India plus the Governor of the state as well. All right. Now, this is the judges of the High Court of a state. All right. And so this is the answer, President plus the CJI plus the Governor of the state. All right. So the correct answer is President plus. All right. This was for the Chief Justice of High Court. Now, for other judges, President basically consults with the Governor plus the CJI of the High Court. All right. So this is for the Chief Justice of the High Court, and this is for the other judges. The question is asking about the other judges, and the correct option still here would be the President, because Governor is only consulted. All right. So the final authority still lies with the President. Answer number B. Option number B. Next question. The concurrent list to the Constitution of India was first introduced by which of the following acts? So a very simple question. This was Act of 1935. See, at that time, which of the words were used? Now we have union list, state list, and concurrent list. That time they had federal list, provincial list, and concurrent list. All right. In the federal list, they have 59 items at that time. In this provincial list, they had 54 items, and in the concurrent, they had 36 items. What is concurrent list? Basically, on which both the union and the state have the right to, enact various kind of laws and acts. All right. So there, other than these, there are residuary powers also. Now, in the Act of 1935, these residuary acts were given under the power of Viceroy. All right. But now, these are for the union government, the residuary powers. All right. So the correct answer was Government of India 1935. Next question. Constitution Assembly, which drafted the Constitution of India, was set up under the very easy one, Cabinet Mission Plan. Now, the Cabinet Mission Plan was basically Cabinet Mission Plan basically gave the plan for making a Constitution Assembly which can actually draft Constitution for India. So there were 3 members in that. There was Lord Pethick Lawrence. I don't feel like calling them Lord and all. Sir Stafford Cripps, and A.P. Alexandra. All right, these 3 were the people. They actually came in March 1946, and then finally they came in March 1946, and finally they gave the plan in May 1946, and finally the Constitution Assembly of India was constituted. It was constituted when? In November 1946. So moving ahead, the correct answer was Cabinet Mission Plan 1946. Next question. The proclamation under Article 356 of the Constitution of India imposing President's rule in a state has to be approved by resolution of both the Houses of Parliament before the expiration of 2 months. 2 months from the date of its issue, the date of the resolution's issue. Now, one more thing I would like to tell you in this question is that if the resolution comes at a point when the Lok Sabha is dissolved or is not in the House, or when the Lok Sabha gets dissolved during the passing of during this 2 months period. So what happens is the extension of the period is given like by 30 days till the time, from the time when the Lok Sabha is actually reconstituted and its first sitting. So the 30 days time is calculated after the 2 months period. The 30 days time is calculated after the first sitting of the reconstituted Lok Sabha. All right. Provided the Rajya Sabha in the meantime has approved that resolution. So 81 answer number, option number C is the correct answer. Next. President of India has the power to nominate 2 members of the Lok Sabha from, very easy question and a basic one, it is Anglo-Indian community if the president feels that the people of this community are not adequately represented. All right. So basically, what is the maximum strength of Lok Sabha at this time? It is 552. So 530 are the people who are the representatives of the states, which are MPs. All right. Then there are 20 elected from the UTs, and then the final 2 are from the Anglo-Indian community. All right. Next question. Which one of the following constitution amendments accorded position of primacy to directive principles of the state policy over fundamental rights? See, let me tell you, the very prime and very important thing here is it was actually done by only one constitution amendment act, but the current status is that fundamental rights actually enjoy supremacy over the directive principles, except the directive principles are of under article number 39B and C, which are actually above the fundamental rights which comes under article 14 and 19. Let me tell you a brief story about it. See, what happened is under the 25th Amendment Act, all right, 25th Amendment Act, it was there in 1971. All right, it was given that any law which would be made to implement the DPSP under article number 39B and C would not be considered as void or we can say unconstitutional on the grounds that it is actually in contravention of the fundamental rights. All right. So they said that these 2 basic rights are these cannot be declared as void. This was under 25th Amendment Act. 2 articles were given. All right. That these will always have supremacy over the fundamental rights. All right. What happened in the 42nd Amendment Act? Under the 42nd Amendment Act, this provision was changed and said that fundamental right, any of the directive principles, not only 39B and C, any of the directive principles cannot be declared as void or unconstitutional by saying that these are in contravention of the fundamental rights. So that any DPSP thing made what? Made the position of directive principles of the state policy as primary over the fundamental rights. All right. So this 42nd Amendment Act actually was declared null and void in the Minerva Mills case in 1980. All right. This was actually declared that this is unconstitutional and void, but finally it was given that okay, finally under Article 14 and 19, if any law is made and it would not be called as it is in contravention with any fundamental rights under Article 14 and 19 if that is related to the implementation of the DPSP under Article 39C, B and C. All right. So finally, there is supremacy of fundamental rights over the directive principles of the state policy, but that does not mean that DPSP cannot be implemented. They can still be implemented by changing the fundamental rights or by amending the fundamental rights, but to the point they are the laws are not touching the basic structure of the constitution. So this was the final declaration. It was given in the Keshwananda Bharti case. All right. So to cut the long story short, the answer is 42nd Amendment Act. Next question. Article 155 to 156 of the Constitution of India deals with the power of President to appoint and dismiss the governors. Very easy one. All right. Next question. The President of India has been empowered to return a bill as soon as possible on the presentation to him after its having been passed by the House of Parliament for assent, except in the case of money bills. Right? Because in case of money bills, he can either approve it or can reject it, but cannot return it for reconsideration. All right. So money bill is the correct answer. And generally, he gives his assent only. He does not withhold or reject also. Why? Because money bill is introduced in the parliament by his own recommendation. So money bill is the correct answer, and president generally gives his assent only. All right. Next question. Which one of the following is not covered under the 73rd Amendment of the Constitution of India? All right. Prudential Plans Commission, Reservation of Seats, State Planning Commission, State Election Commission. So the correct answer is option number C, which is State Planning Commission. There is no provision related to SPC in the 73rd Amendment Act related to the Panchayati Raj. All right. Next question. The 7th schedule of the Constitution of India contains very easy one. It should not take you even more, not even 1 second to mark this question if you have very well read polity. All right. Next question. Who among the following is ex officio chairman of the Council of States? Again, a very easy one. It is the President of India. Vice President of India. Option number B. Okay. Next question. Which one of the following articles of the Constitution empowers the Parliament to create one or more All India services? Again, a very easy one. The correct answer is option number 30, D, article number 312 and 1. If the Rajya Sabha, this article says that if Rajya Sabha passes a resolution declaring that it is necessary in the interest of the, or it is necessary in the national interest to do so, so more seats are, or more All India services can be created under article 312. So basically, Rajya Sabha has a prime role in this case. All right, next question. How many members are nominated by the president to the Rajya Sabha? See, in Lok Sabha there were 2 and in Rajya Sabha there are 12 members. 12 members who all are there who have specialized knowledge or primary experience in the field of literature, people who have experience and knowledge, specialized knowledge in the field of literature, science, art and social service. All right. Next question. The 106th Constitutional Amendment Bill, not the Act, relates to which of the following? It is related to cooperative societies. All right. This bill was actually introduced in 2006. It was basically introduced for introduced for empowering the cooperative societies also through voluntary formations, so that they can voluntarily be formed. Voluntary formations, autonomous functioning, democratic control, and professional management. But at that time, this bill could not be passed because the Lok Sabha, by the Lok Sabha, it could not be passed. And finally, what is the final constitutional amendment bill for this act? It is the 97th Amendment Act 2011, which actually gave the constitutional status to the cooperative societies. All right, for all these functions. So it initially started with the bill being introduced in 2006 and finally in 2011 by 97th Constitutional Amendment Act, it was finally, the cooperative societies were finally given the constitutional status. Which one of the following statements correctly describes the 4th schedule of the Constitution of India? What It contains scheme of distribution of powers, languages, provisions regarding the administration of tribal areas, or it allocates seats in the Council of States. It actually allocates seats in the Council of States. So this is directly a straightforward question being asked from the schedules, which is 4th schedule. Next question, adjudication of disputes relating to the interstate river water are made by Union Parliament, High Courts, Supreme Court, tribunals set up by the Union Government. Interstate river water disputes. These are adjudication of these disputes are done by the Union Parliament. All right. Answer A is the correct option for this. Next question. The reports of the State Public Service Commissions are presented annually to whom? Annually to the respective governors, who then forwards the reports to the state legislatures concerned. All right, so the correct answer is option number C. Why option number C? Because the Service Public Commission of the states. So governors are given of the states these reports, and they finally presents these or place these reports on the table of their state legislatures concerned. All right. Next question. Which one of the following is not correct with regard to Article 243ZT of the Constitution of India? All right. So here, option number A says, in every state at the district level, there shall be a district planning committee. All right. B says, the draft development plan must have regard to matters of common interest between. All right. Legislatures of a state may make provision for the composition of this. All right. The development plans are forwarded to the state planning commissions. No, as I told you, there is no mention of state planning commission in 73rd Amendment Act itself. So option B is the correct answer here. All right, because it is asking not correct. Next question. In 1947, India had municipal corporations at where? In Madras, Calcutta, Delhi, Lucknow, Calcutta, Bombay, Madras, Calcutta, Bombay, or Lucknow, Calcutta, Madras. It is in Madras, Calcutta, and Bombay. Option number C is the correct answer. All right. Next question. Which one of the following is not an objective of the non-aligned movement? See, very easy one. Tell. It is option number A is establishment of world peace. All right. To contribute to the game of power politics. Doesn't it sound to be very negative? It should be marked in one go that the option number B is incorrect one. All right. Next one. According to Article 107 of the Constitution of India, in matters of ordinary legislation, Lok Sabha has been given more power, Rajya Sabha, Speaker, or both houses. I guess it is a very easy question, and anyone could actually, mark it in one instance, that is, both the houses have been given equal powers. In case of money bills or financial bills, obviously, certainly there are more powers given to Lok Sabha, but in ordinary legislation case, both the houses have been given equal powers. All right. Now, the next one, the members of the Union Council of Ministers are collectively responsible to Union Council of Ministers, Lok Sabha, Rajya Sabha, President, or both Lok Sabha and Rajya Sabha. It is the Council of Ministers are basically responsible to specifically Lok Sabha. In general, we say Parliament, but it is to be very specific. It is, and they are responsible to the Lok Sabha. All right. So there is this collective responsibility.
Which one of the following festival is celebrated every year in Ladakh in the month of February? तो वो कौन सा त्योहार है? वो है डोसमोशे. ठीक है, ये क्या होता है? न्यू ईयर के सेलिब्रेशन होते हैं. वहां पे दो प्रकार के सेलिब्रेशन है, एक लोसार और एक डोसमोशे. सो करेक्ट आंसर इज ऑप्शन बी. आगे बढ़ते हैं. In February 2015, India signed a bilateral agreement on civil nuclear cooperation with Sri Lanka. ठीक है, तो अब आप यहाँ पे एक चीज देखिए, जो करंट अफेयर्स जो ALC या फिर UPSC के रिक्रूटमेंट एग्जाम्स में पूछे जाते हैं, दे आर मोर ऑफ बेस्ड ऑन अ फैक्चुअल इंफॉर्मेशन. उसमें उस प्रकार के कॉन्सेप्चुअल अंडरस्टैंडिंग नहीं चाहिए, यानी एनालिटिकल अप्रोच उसमें इतनी नहीं चाहिए जितनी वो फैक्चुअल इंफॉर्मेशन इंपॉर्टेंट है. तो इसी तरीके से आप अपने करंट अफेयर्स को टारगेट करना. ठीक है, आगे बढ़ते हैं. व्हाट इज वनाज 2015? तो वनाज 2015 क्या था? नेशनल ट्राइबल फेस्टिवल, जो कि दिल्ली में हेल्ड हुआ था. ठीक है, तो करेक्ट आंसर इज दिस। द 35th नेशनल गेम्स ऑफ इंडिया वाज हेल्ड इन, उस टाइम पे ये केरला में हुआ था। करेंटली ये सितंबर मंथ के एंड में गुजरात में होने वाला है। सो फॉर आवर्स टाइम द करेक्ट आंसर इज गुजरात। ठीक है, हु अमंग द फॉलोइंग इज द 50th रेसिपिएंट ऑफ द ज्ञानपीठ अवार्ड। तो 50th रेसिपिएंट ऑफ ज्ञानपीठ अवार्ड उस टाइम पे कौन था, हम उस पे नहीं जाएंगे, पर दामोदर मौजो जो प्रेजेंटली ज्ञानपीठ अवार्ड जिनको मिला है उनका नाम है, जो कि गोवा के कोंकणी राइटर हैं। ठीक है, Who among the following is the winner of the Australian Open Man Single Tennis Tournament? अगेन मैं इसको काट के 2022 कर रहा हूं और इसका करेक्ट आंसर है राफेल नडाल। ठीक है, अगेन जैसा कि आप लोग ने ऑब्जर्व किया होगा, दे आर मोर ऑफ अ फैक्चुअल वन एंड उसमें आपको एनालिटिकल अप्रोच नहीं यूज करनी है।
Next one. Mr. M can drive from Rampur to Sitapur by two alternative routes. So Rampur to Sitapur. So there is route 1 and then there is route 2. Okay. So road 1 is 20 kilometer longer than road 2. So this distance is D. Then this is D plus 20. Okay. So what else do we know? But it is in a good condition and he can drive at a constant normal speed. Road 2 is in a bad condition and he has to drive at a speed of 20 km per hour slower. So speed over here is V, then speed over here becomes V minus 20. Okay. But it takes same time while traveling from two roads. So what do we understand? We understand that the time through road 1 will be what? D plus 20 by V, and road 2 will be D over V minus 20. Okay. So dV plus 20V minus 400 dV and it will be minus 20D is equal to dV. dV cancels out. So guys, what do we get? We get V is equal to D plus 20. V is equal to D plus 20. Or because V is equal to D plus 20, this is the time taken while going through road 1. So road 1 में कितना टाइम लगा? D plus 20 by V, और D plus 20 V के बराबर है, इसका V by V, इसका मतलब रोड 1 में जाने में कितना टाइम लगा? 1 घंटा। सो रोड 1 में जाने में 1 घंटा लगता है। ठीक है। आफ्टर रोड 2 इज रिपेयर्ड, सो अगर रोड 2 को हम लोग रिपेयर कर देंगे, सो रोड 2 को अगर हम रिपेयर कर देंगे, हाउ लॉन्ग विल इट टेक एट हिज नॉर्मल स्पीड? सो गाइज, अगर हम रोड 2 को रिपेयर कर देंगे, ऑफ कोर्स इट मींस ही विल बी एबल टू ट्रेवल एट द नॉर्मल स्पीड। अभी उसको रोड 1 रोड 2 दोनों में जाने में 1 घंटा लग रहा है, 1 घंटा इसमें 1 घंटा इसमें। अगर रोड 2 को हम लोग रिपेयर कर देंगे तो क्या होगा? रोड 2 की जो स्पीड है वो V minus 20 से बढ़ के V हो जाएगी, इसका मतलब स्पीड ज्यादा हो जाएगी। अगर स्पीड ज्यादा हो जाएगी तो टाइम कम लगेगा, गिवन दैट डिस्टेंस इज सेम। सो करेक्ट आंसर इज A, less than 1 hour. Next one. R was born when his father A was 27 years old. Okay. So let us write it. Maybe father is A. ठीक है. Father is A. So positive sign because of father. ठीक है. And R is I think son or daughter of A whatever. ठीक है. उसके बाद A's brother is of same age as R's brother. इसका मतलब R की मदर कौन है? A की वाइफ है। सो A के पास एक वाइफ है, सो डबल डैश से आई राइट इट वाइफ, नेगेटिव साइन फॉर द फीमेल, और A का एक भाई भी है। सो भाई को मैं लिख लेता हूँ B ब्रदर, अगेन पॉजिटिव साइन, सिंगल लाइन बिकॉज दे आर सिबलिंग्स, डबल लाइन व्हेन पीपल आर मैरिड। आप खुद कोई भी नोटेशन आप अपना लगा सकते हो। ठीक है। उसके बाद दिया कि A का जो भाई है ही इज ऑफ सेम एज एज आर मदर, मतलब A का जो भाई है उसका जो एज है वो उसकी वाइफ की एज के बराबर। अगर इसका एज x है तो इसका एज भी कितना है? x है। ठीक है। अब A इज 3 year older देन ब्रदर, अब A का कितना हो गया? x plus 3, और R was born when A फादर was 27 years old, इसका मतलब उसका बेटा की 27 साल उसकी एज से कम होगा, जितना भी होगा। So x minus 3 minus 27, x plus 3 minus 27, it comes out to be x minus 24 एज कितना हो गया? R का हो गया। ठीक है। उसके बाद क्या दिया है कि R got married, उसका हमें दिया R got married on his mother 50th birthday। सो जो मदर जिसकी एज x है, जब वो 50 थी, तब आर का शादी हुआ, तो आर का एज कितना था? सो आर का एज विल बी एक्स की वैल्यू 50 माइनस 24 इज इक्वल टू 26. करेक्ट आंसर इज बी. Next one. Which one of the following is the next entry? So guys, again very simple question of the letter series. अगर इसमें तुम देखोगे x y z, so -1 का डिफरेंस है, इसमें s s s s u w, इसमें बीच में एक लेटर का गैप है, तो दिस इज द डिफरेंस ऑफ -2. इसमें कितने का है? इसमें 2 लेटर बीच में है, सो -3. सो अगले में क्या होगा? -4 एंड इट विल बी QMI. अगेन अगर किसी को थोड़ा डाउट है तो अपना ये लिख के ABCDE ऐसे लिख के एंड देन राइट द नंबर्स 1 2 3 4 5 26 तक, और इनके नंबर लिख लेना, अपने आप ही तुम्हें सीरीज दिखाई दे जाएगा जो भी इसमें पैटर्न दिया हुआ है. ठीक है. नेक्स्ट वन, विच ऑफ द फॉलोइंग इज द नेक्स्ट एंट्री? सो 1 2 3. सो इसमें क्या है कि 1 2 3 को सम कर देते हैं. सो 1 + 2 + 3 कितना हो गया? 6. ठीक है. देन वी मल्टीप्लाई दिस बाय 2, वी गेट 12. सो अगला नंबर क्या है? 123 + 12 इज इक्वल टू 135. नेक्स्ट क्या ट्रेंड है इसके बाद? अगेन विल ऐड. सो 1 + 3 + 5, 5 और 3 8 और 1 9. अब की बार मल्टीप्लाई करेंगे हम 3 से. ठीक है. सो इट विल 27. सो अगला सीरीज क्या है? 135 + 27 इज इक्वल टू 162. ठीक इस तरह अगर अगला देखेंगे तुम लोग खुद से चेक कर लेना. इट विल बी 1 + 6 + 2 इज इक्वल टू 9, और 9 को मल्टीप्लाई करेंगे अब की बार 4 से. सो 2 से 3 से 4 से, सो 36. सो 162 + 36 इज इक्वल टू 198. तो अगला सीरीज क्या होना चाहिए? नेक्स्ट शुड बी 198. सो 1 + 9 + 8, सो 9 और 8 17 और 1 18. 18 को मल्टीप्लाई करेंगे अब की बार 2 3 4 5 से 90. सो 198 + 90 इट कम्स आउट टू बी 288. करेक्ट आंसर इज ए. आगे बढ़ते हैं. नेक्स्ट वन. A printer numbers the pages of book starting from 1 and uses 3 1 8 9 digit in all. How many pages are there in the book? So जब हम लोग 1 से 9 तक लिखेंगे तो कितना डिजिट यूज होगा? 9. जब 10 से 99 तक लिखेंगे तो हर एक नंबर में दो डिजिट हैं, और ये कितने नंबर है? 90. सो 90 × 2 180. जब हम लोग 100 से 999 तक लिखेंगे तो ये कितने नंबर है? 900. हर एक में कितना डिजिट यूज हुआ? 3, तो 2700. सो टोटल कितने अब तक हमने यूज कर लिए? 9 + 180 + 2700, एंड दिस कम्स आउट टू बी कितना? 2889. ये हमने यूज कर लिया. टोटल हमारे पास कितना है? 3189. तो अभी कितना डिजिट और हमारे पास बाकी बचा है जो हम यूज कर सकते हैं? -2889, एंड दिस कम्स आउट टू बी 300. अब इसके बाद नंबर किससे शुरू होंगे? 1000 से, और वो कहां तक जाएंगे वो हमें बताना है. हर एक नंबर में 4 डिजिट यूज हो रहा है. सो 300 डिवाइड बाई 4 75. मतलब 75 नंबर हम लोग और लिख सकते हैं. सो 1000 से 75 नंबर कितना होगा? 1075 नहीं होगा क्योंकि 1000 भी नंबर है. सो 1074 होगा. करेक्ट आंसर इज सी. Next one. In a certain language, 1 2 3 is bright little boy. ठीक है. उसके बाद 1 4 5 is what? Tall big boy. अगर तुम यहां देखोगे इन दोनों में, क्या रिपीट है? 1 दोनों में सेम है, और यहां सेम क्या है? बॉय. तो हम इससे पता क्या चलता है कि जो बॉय है, बॉय इज 1. बॉय को 1 हमने कर लिया. ठीक है. आगे देखते हैं. 637 इज ब्यूटीफुल लिटिल फ्लावर. अब इन दोनों में क्या कॉमन है? 637 और 1 2 3 में 3 कॉमन है. करेक्ट. 3 कॉमन है, और इन दोनों में वर्ड कौन सा कॉमन है? लिटिल. इसका मतलब लिटिल को हमने क्या दे दिया? 3. निकालना क्या है हमें? निकालना है हमें कि ब्राइट क्या है. सो अगर इस वाले को हम देखेंगे, इफ यू लुक एट दिस वन, इसमें लिटिल के लिए है 3, बॉय के लिए 1, तो ब्राइट के लिए क्या बचा 2, देयरफॉर करेक्ट आंसर इज ए। ओके, नेक्स्ट वन, find the odd one out. So guys, all of them are 2D objects except sphere, which is 3D object. Correct answer is D. Next one, इससे आसान सवाल तो बनना मुश्किल है किसी भी पेपर में। P is twice of Q, Q is thrice of R, R is 4 times S, S is 2। अगर S 2 है तो R कितना हो गया 8, ये है तो कितना 24 और ये कितना 48। करेक्ट आंसर इज बी। Ratio of circles inscribed and circumscribed on an equilateral triangle। So अगर मेरा एक equilateral triangle है, ठीक है, और of side A, then there is a in circle। तो इस इन सर्कल का रेडियस कितना होता है गाइस? अगेन ये छोटे छोटे रिजल्ट शायद लोगों को याद होना चाहिए। A to root 3, and if we look at circle, its radius by capital R, it will be A by root 3। ठीक है, हमें क्या निकालना है? रेशियो ऑफ देयर एरियाज निकालना है। सो एज यू कैन सी ये इसका हाफ है। अगर एरिया निकालेंगे तो पाई आर स्क्वायर, मतलब इट विल बी स्क्वायर ऑफ दैट। अगर ये इसका हाफ है उसका स्क्वायर मतलब 4 टाइम्स। करेक्ट आंसर इज सी। बाकी कुछ लोग निकाल के भी देख सकते हैं पाई आर स्क्वायर में वैल्यूज को रख के। A man invests ₹100 for 3 years at compound interest at the rate of 4% per annum, 5% per annum for second and third year। So जो 100 रुपए थे, एक साल बाद कितने बन जाएंगे? 1.04। अब ये पैसे अगले 2 साल बाद कितने बन जाएंगे? इतने। फिर 3 साल बाद कितने बन जाएंगे? इतने। कैलकुलेट कर लेना इसको, 114.66। करेक्ट आंसर इज बी। आगे बढ़ते हैं। Distance from point A to B is 20 kilometers। A person is driving the car at the rate of 40 kilometers per hour। Each wheel of car is rotated 10,000 times by the time it reaches point A to B। If person drives at 60 kilometers per hour, तो स्पीड बढ़ा दिया, तो अब की बार कितनी बार व्हील रोटेट करेगा? सो गाइस, बहुत ही बढ़िया सवाल। अब जो व्हील रोटेट क्या करता है? व्हील तो अपना डिस्टेंस कवर करेगा, राइट? अब डिस्टेंस तेजी से कवर होता है या उससे क्या होता है? उससे कुछ फर्क नहीं पड़ेगा, राइट? नंबर ऑफ रिवोल्यूशन विल बी सेम इवन इफ स्पीड इज फास्टर। सो व्हाट? देयरफॉर द ईच विल रोटेट 10,000 टाइम्स ओनली। इस बात से फर्क पड़ता है नहीं कि स्पीड ज्यादा हो गया या कम हो गया। करेक्ट आंसर इज ए। करके देख लेना एक व्हील को ऐसे जमीन पे एक बार चला के, स्पीड से नंबर ऑफ रोटेशन कोई फर्क नहीं पड़ेगा। ओके। A cube of side 4 centimeter is painted on all 6 faces with same color। It is then broken into smaller cubes of side 1 centimeter each। अब कितने? सो गाइस, अगर क्यूब 4 का है तो टोटल कितने बनेंगे? 4 4 4, जैसे मतलब बेसिकली तुम्हें इसको ना थोड़ा समझना होगा। तो 1 2 3 1 2 3 ये वाला क्यूब है, ठीक है। तो अब ठीक है, इतने से समझाने की कोशिश करता हूं तुम लोगों को। नहीं, मुझे एक और चाहिए असल में। ठीक है, आई थिंक इतने से हम समझा पाएंगे। ठीक है, तो अगर तुम इस क्यूब को, इसमें टोटल क्यूब कितने होंगे? 4 into 4 into 4। सो टोटल क्यूब विल बी 64। अगर मुझे निकालना है कि ऐसे कितने क्यूब है जिसकी कोई भी साइड पेंटेड नहीं है, नो साइड्स आर पेंटेड, नो साइड्स आर पेंटेड, तो अंदर वाले होंगे, अंदर जो दिखाई नहीं दे रहा है। सो अगर 4 4 क्यूब है किसी भी साइड पे, तो अंदर वाले 2 2, मतलब एक ही साइड से हट जाएगा। सो दे विल बी 2 into 2 into 2। सो नो साइड वाले हो जाएंगे 8। ठीक है, अगर हमसे पूछते हैं कि अब जिसकी सिर्फ एक साइड पेंट हो, वन साइड पेंट, ये कैसे? वन साइड वाले कौन से होंगे? ये वाले 1 2 3 4। ठीक है, और ये कितने फेसिज हैं? 6 फेसिज हैं। सो 4 into 6 24। अब अगर 2 साइड पेंट हमें निकालना है, तो 2 साइड पेंट गाइस कौन से वाले होंगे? 2 साइड पेंट में रेड कलर से मैं बताता हूँ। 2 साइड वाले होंगे जैसे ये, फिर ये 2 होंगे। और ये कितने, अब ये कितनी साइड्स हैं? 4 4 8 और 4 12। क्यूब को देख लेना एक बार, 24। अब 3 साइड पेंट वाले हमें निकालने हैं। 3 साइड वाले कौन से होंगे? 3 साइड वाले होंगे ये वाले कॉर्नर वाले, ये वाला क्यूब। बी वाले कितने कॉर्नर है? 8, तो 3 साइड वाले 8 होंगे। सो गाइज अगर तुम देखो 9 साइड वाले 8, 1 साइड वाले 24, 2 वाले 24 और 3 वाले 8। रेशो किसका निकालना है? रेशो हमें निकालना है नो पेंट 8 टू 1 फेस पेंट 24, फिर 2 फेस पेंट 24। ये हो गया 1:3:3। करेक्ट आंसर इज डी। ओके, next one. 3 are alike, 1 is not, so which one doesn't belong to group? Needle, nail, pin, hammer is not part of the group. Hammer से बाकी सबको हम क्या करते हैं? ठोकते हैं, right? Okay. In a certain code, rainbow is coded as XP something. So guys, again trend देखना है. So this R becomes S with a +1. A becomes B again with +1. तो इतने से ट्रेंड निकालने की कोशिश करते हैं. So this R will become the last letter with the +1. So R +1 is S. ठीक है. I will become the second last letter again with +1. So I +1 is J. So JS लास्ट में होना चाहिए, जो कि इसमें भी है इसमें भी है. चलो 2 चॉइसेस एलिमिनेट हो गया. अब तीसरा देखते हैं N, लेकिन यहाँ पहले देख लें. So my I goes to J. So again +1. इसका मतलब मेरा N will become this but with +1. So N +1 क्या होगा? LMNO. O will be there. So OJS कहाँ है? यहाँ है. Therefore correct answer is C. Done. Guys, पूरा निकालने की जरूरत नहीं होती है, उतने से तुम्हें ट्रेंड मिल जाना चाहिए. नेक्स्ट वन, प्रोबेबिलिटी ऑफ हैपनिंग अ इवेंट कैन बी. गाइस प्रोबेबिलिटी हमेशा होती है 0 से 1 के बीच में, 0 और 1 इंक्लूडेड किसी भी इवेंट की. सो -1 कभी प्रोबेबिलिटी नहीं हो सकता. देयरफॉर करेक्ट आंसर इज डी. इन दिस शॉर्ट वीडियो वील अंडरस्टैंड हाउ यू गाइस विल प्रिपेयर फॉर UPSC Labour Enforcement Officer exam with human peritus. So to make you understand that process, let us go to website of human peritus. So once you are on the home page of human peritus, we'll go to the page for Labour Enforcement Officer UPSC, and once we are on this page, we'll come to this section where it is given how you will prepare with us. So as you can see, there are 4 steps of preparation. So let me explain you what you will do in these 4 steps for preparation of UPSC LEO. So guys, सबसे पहले आप लोग क्या करोगे, and let us understand that with an example. Take any keyword of the syllabus. So maybe you can take Factories Act, or you can take motivation theories under HR. Okay. So let us take the keyword of motivation theory. So the first thing which we will do is that you will read the topic of motivation theory through the concise printed booklets which we'll send at your home via courier. So these are quite concise booklets, and they will provide you 100% coverage of the syllabus. Current affairs are also included in these booklets only. So once you have gone through that particular keyword of Factories Act or motivation theory, whatever you have selected, you'll go to the second step. So guys, these video classes will make you understand that keyword conceptually. So teacher will add its own value by telling you how to remember what is more important, what is less important, and conceptually explain. Mind it, in these live classes, you can interact with the teacher. And interaction का मतलब ये नहीं है कि you can just chat and ask your doubts. You'll be speaking your doubts to the teacher. Guys, your mic will be turned on, और आप डायरेक्टली टीचर से आप क्लास में बात करके अपने डाउट डिस्कस करोगे एज इफ यू आर इन अ physical class, not just chat option which you get at most of the places these days. Another thing, if you miss any class, definitely you'll end up missing few classes because of your time. You will also get recorded video of every class. Now, so these are step number 1 and step number 2. Step number 1 is concise booklet. Step number 2 is video classes. अब कुछ लोग ऐसे भी करते हैं that they will watch video classes first and they will read, and then they will read from the booklet. So that depends upon you how you guys want to take it. But these are the 2 steps. Now, if you want to assess the quality of teaching in these video classes, quality and style of teaching in these video classes, तो आपको क्या करना है, on the same page on the website, go down and we have put up 8 to 10 classes of different teachers of and different subjects. Like एक हमने लेबर लॉज का क्लास डाल दिया, एक HR का, एक OB का, एक न्यूमेरिकल एप्टीट्यूड का, एंड एक पॉलिटिक एंड सो ऑन, so that you will get a very क्लियर आइडिया कि किस तरीके से क्लास में टीचर पढ़ाते हैं एंड हाउ कंफर्टेबल आर यू विद दैट स्टाइल एंड क्वालिटी ऑफ टीचिंग. सो यू कैन गो थ्रू सम ऑफ दीज क्लासेस टू रिव्यू द क्लासेस. ठीक है. अनदर थिंग गाइज, इफ यू वांट टू assess the quality of content in the concise booklets, again go to this section on the same page, check out how printed booklets look like, और इसमें से आप कोई भी एक दो बुकलेट उठा के जो हम लोगों ने दिया हुआ है, you can go through and look at the quality of content in these printed booklets. Again, these are the sample booklets, पर आपको index page पूरा दिखेगा, उसके अलावा 10-15 pages भी दिखेंगे, and this will give you a good idea how content has been arranged in these concise booklets. Now guys, step number 1 and step number 2 are done. So you have understood that particular keyword from booklets as well as video classes. Then we'll move on to step number 3. And this is the most important step. Step number 3 is what? Step number 3 is a online question bank, which has got more than 7,000 questions. But these 7,000 questions have been subdivided in more than 120 सब टॉपिक्स. ठीक है. जैसे कि पूरे HR को हमने कम से कम 18-20 टॉपिक में डिवाइड कर दिया. हर एक में कुछ होंगे 40 सवाल, 50 सवाल, 80 सवाल, 100 सवाल, छोटे छोटे हमने उसे कर दिया. सो एक बार अगर आपने फैक्ट्रीज एक्ट का टॉपिक बुकलेट और वीडियो क्लास में आपने समझ लिया है, सो you'll go on the online test platform and for this one particular topic only of factories act or motivation theory, you will do around 80 to 100 questions for that particular topic only. ठीक है. तो सिमिलरली आप एक एक कीवर्ड उठा के आप अपना सारा सिलेबस पूरे करते जाओगे by going through these 3 steps. Now guys, 2-3 things which I want to tell you about this online question bank. Number 1, these are not random questions, they have been carefully chosen. तो इसमें कहाँ से सवाल हैं? Of course जो प्रीवियस ईयर के पेपर के क्वेश्चंस है वो हमने इसमें डाल दिए हैं. So not only LEO and ALC, जो UPSC के बाकी रिक्रूटमेंट एग्जाम्स हैं, जैसे कि EPFO, ESICDD, एडमिन ऑफिसर, स्टोर ऑफिसर, APFC, इसके जितने भी पेपर हुए हैं पिछले 8-9 साल में, आई थिंक 18 से 20 पेपर हुए हैं टोटल यूपीएससी के, वो सारे के सारे क्वेश्चन इसमें आपको मिलेंगे. ऑफ कोर्स हमने इसको तोड़ दिया है. व्हाई? बिकॉज वी वांटेड टू गिव यू रेलेवेंट क्वेश्चंस ओनली. फॉर एग्जांपल, इनमें से कुछ एग्जाम्स में कंप्यूटर नॉलेज के सवाल भी आते हैं, इंग्लिश लैंग्वेज के भी आते हैं, या फिर इंडियन इकोनॉमी के आते हैं, फ्रीडम स्ट्रगल के आते हैं. ये सब हमने आपके ऑनलाइन प्लेटफॉर्म से हटा दिया है. सो यू विल गो थ्रू ओनली relevant questions only from these exams. उसके अलावा जो यूपीएससी के रेगुलर एग्जाम्स हैं, CISF, CAPF या यूपीएससी सिविल सर्विसेज, वहां से भी जो ओनली दोज आर रेलेवेंट क्वेश्चंस, तो वो वाले सवाल भी हमने इस क्वेश्चन बैंक में हमने इसमें डाल दिए. सो ये सारे क्वेश्चंस आर केयरफुली चूजन. इट इज नॉट दैट रैंडमली वी हैव बिल्ट अप अ 7,000-8,000 क्वेश्चन बैंक. नो, दे आर वेरी केयरफुली चूजन. हर एक को हमने उसमें डाला है. Another thing guys, every question comes with detailed explanation. So why that is important? अगर आप कोई क्वेश्चन करोगे और आपको वो नहीं समझ में आता है तो उसका आंसर देखोगे, then you will go through detailed explanation of with the answer, so that आपको उस क्वेश्चन को करने के लिए दोबारा से बुक या वीडियो नहीं देखना पड़ेगा. Then and there you will understand it. So these 3 steps: online question bank, concise booklets and video classes. Through these 3 steps, you will cover entire syllabus which has been prescribed by UPSC, जिसको हमने further subdivide किया approximately 120 keywords में. Okay, great. अब if you have done this, you are ready for the exam. Finally, step number 4 क्या है? That you need to be ready for the exam day as well. ठीक है? So under step number 4, you will write some mock test papers. So idea of mock test is not to make you learn anything new, और नहीं ऐसा होता है कि mock test में जो सवाल है वो repeat हो जाएंगे, नहीं. So idea of mock test is to teach you time management for the exam day, how you will handle yourself for the exam day. So you'll write 5 full-length mock test paper. They are on the exactly same kind of platform as the CBT which you will get in the actual UPSC, ताकि आपको उसका पूरा practice हो जाएगा. So guys, what is our promise? If you go through these 4 steps with human apparatus, आपको इसके अलावा कुछ नहीं करना है. You don't have to touch any other book. You don't have to look at previous year papers. Nothing else. Whatever will give you, even if you have some books, put them aside. Whatever will give you, go through that and you will be ready for the exam. We adopted the same approach in previous exam in 2017. There were 35 seats all over India. Out of them, 7 people were from human apparatus preparation plan. So every 5th guy in the country was a human apparatus student, and we are pretty confident. अगर आप ये हमारे साथ कर लेते हो, then you do not need anything else, and it will take some time. It will also take 3 to 4 months. It is not easy job, ठीक है? Labor Act का एक लाइन याद करना या पूरा जो हम आपको बताएंगे to go through around 200 hours of video classes. लेकिन slowly if you build up, if you will keep preparing every day for 2-3 hours per day, this you are done. इसके अलावा कुछ भी नहीं छूना है. With lot of responsibility, we are saying you that you don't have to, even current affairs, that is also a responsibility. We'll tell you कि current affair में तुम्हें क्या पढ़ना और क्या नहीं पढ़ना है. So guys, you are welcome. You can enroll by paying online through the same website only. So you have got option 1, option 2, option 3. Through these options you can join. I'll advise कि you come for the live classes so that you get the real value. And if you have any other doubt, you want to ask anything, you want to discuss anything, you want to agree with us, you want to disagree with us, you are most welcome. So you can call us anytime. There is also another link given in the description below. If you'll click on that link, that will connect you directly with our team via WhatsApp. Click on that link, get connected, and do let us know whatever you feel like. All the best.